Um, Today, Kim and I are going to talk about deconstructing a license. As I mentioned in the other one, we're going to focus on a publishing agreement. However, this is just one of many, many examples of what a copyright license could look like. And this one in particular that we're going to go through definitely isn't like a one-size-fits-all, but it's a great example of what you should look for in standard clauses with a copyright license.
And I think we agree that it's just going to be sort of conversational. It's for your benefit. So we have a way that we're going to walk through it. We're going to walk through particular clauses in a certain amount of order. Just to give you an overview, we're going to talk first about copyright basics. I think they've been covered, but it can't hurt, right? Because it is complicated. So the more times you hear the definition, sometimes you're like, oh, that word's pretty key. Now I've heard it 4 times. I think that's the one that will matter to me. But we'll walk through some standard clauses that you should see in any contract where you're granting some license to someone to do something. Then we'll kind of step back and look at it from the licensor, which would be, in this case, like the author, someone who's granting the rights, and then the licensee, the person receiving. Particularly in publishing, they're very pro-licensee, sometimes pretty egregious. But anyway, so I think I'll try and interject a few like anecdotes, things, horror stories, whatever, just to kind of, I think that cements some of the ideas for you. But please ask questions. We have left a little bit of time at the end as well. And we're going to be kind of bouncing off each other. So hopefully that'll make it feel more conversational and you'll jump in. So again, copyright basics. We just wanted to go over the fact that there's two differences, and I think that's been covered to some extent. The difference between something that's federally registered, where you fill out a form, you pay a fee, and you get a number. And with that, if you've done it in a particular amount of time after you've created it, you get extra rights that are in the statute. You have rights anyway. Those are what we call common law rights. That is something that the Constitution has said, as soon as it's fixed in a tangible medium, you get it, and that's fine. We just wanted to highlight the fact that there are enhanced damages with prompt registration, and depending on the type of work that you're making, because it can seem cost prohibitive, one thing that I've seen people do with some success is to do like a seasonal registration. Say, for example, you're a photographer. Maybe you want to register your spring work, your summer work, your fall work. At least you've got something on record within 3 months of creation that you can rely on. Ideally, if you have a particular piece that's going to really be the moneymaker, then you're going to want to register that alone, because to some extent the analysis is the amount of the work that was used. If you've registered 100 things together, then the proportion of what was used will be analyzed differently. So, but just as one way of protecting yourself, think about that. Again, it only protects the original and creative expression, not the ideas. I think we've covered this pretty sufficiently, so we can move on probably. But if you have any questions, please let me know. I wanted to walk through a little bit of the process. The Copyright Office is within the Library of Congress, and the idea is just a way for us as a nation to kind of catalog this stuff. And that's essentially all they do. There's not a lot of examination. There's a presumption that if you filed for the registration, you're the author. There's not an analysis, well, gee, this looks like somebody else's who helped you with this. There's none of that. So that's good and bad. It means that that stuff can be raised later, but again, it's a presumption that has to be overcome. There are no state copyrights. It is federal law. Again, when you want to register this, pre and post publication, I put that in quotes because publication doesn't mean what you think it does necessarily. Publication can mean you printed it and distributed it, but it basically means giving it to others in a format where they can enjoy it. So it's a lending, like once you've lent the work out. So it does not necessarily mean that you've actually published it in the common sense of the word. Most of these can be submitted electronically. Some of them have to be done in hard copy, sometimes in duplicate. All of this is laid out on copyright.gov. The website, they're pretty extensive in the tutorials that they provide for you. I still feel like they're government forms, so they're a little onerous, but I think the more familiarity you get with them, the better. And there's almost always something written on the topic on the site that you can find to dig in. And again, the fees are fairly small compared to some of the other forms of IP protection. Yes, go ahead. Sure.
On the publication?
Yes.
Does that means if you lend it or give it to others, does that mean if you present it to a company or you show it?
Yep.
Is that That's publication?
Yes, once you've kind of given it up. Yeah, in that.
You've given it out to show somebody to consider.
If I sell it in a gallery, I've published it, that kind of thing. So some of that aspect. I think
prospective licensee, is that considered?
I would have to look into that if it's more like an offer for sale in the patent context. I wonder at what point does that become a real offer? You know, at what point have you really transferred their ability to enjoy it? I think if you're just in preliminary talks, probably not. But I think at the end of the day, for the price point, maybe you should just, as a preemptive measure, have your process be that you register it and then talk, just regardless of whether that publication moment happens 2 days later or or what. So I think from a practical matter, I would assume that it happened. Whether it does in court, if you were disputing that fact, I don't, you know. And I'm not sure how much case law is actually on point there. Like if you registered it in 3 months and 2 days, are you going to not get, you know what I mean? Like you may know better how many cases have come down on that. But I have a feeling that a lot of these things are pronounced in a statute, and then until someone challenges them, we really don't know where the meat is. So we're careful. And lawyers are risk averse mostly, so we always caution you to have belts and suspenders or whatever. So again, so fair use, if you weren't in that section of today, I think it's worth going over. It's a multi-factor balancing test. Basically, it's a defense to infringement. As we said before, infringing someone's copyright is using it without their permission. And using their copyright without their permission could be any of those 5 enumerated rights, which were copying, distributing, performing publicly, publicly displaying it, or creating a derivative work. Basically, it comes down to a First Amendment balancing. We want the Constitution's given this right, but they also have a lot of rights about free speech that are incredibly important to us here. And so they're trying to go through that. They're trying to find out what's the purpose and the character of the use that you're doing, the infringement. What's the nature of the work, the amount and the substantiality, like I said before. How much of the work have you used? On that note, there is no such thing as that ability to sample for a short amount of time. It's not a matter of like, oh, I can play 4 notes but not 5, or there's none of that. The effect of the use usually comes down to the fact where have you stolen the market from someone. If there were really no damages, then that factor will play very, very poorly if you're the author. And then there's also this aspect where there's kind of anything else the court finds important that day. So that's where the case law gets really squirrely. I think sometimes you can read a fair use case and see very clearly why the court came down the way they did, and other times it's just not clear. Commercial, whether it's a commercial enterprise, does have some importance. Whether you've taken a market away from an author, if you've and if it's pre-publication, if the author has not yet published their work and you rush to market with their stuff, that's very frowned upon. And again, it comes down to that idea, that integrity of the work. We want the author to be able to decide when and how things get distributed. So with that backdrop, we can start to walk through a license. Anytime you want to jump in.
Okay.
I could talk all day. Sorry.
So the license we handed out, and if you didn't get a copy, there's some more right on this table, right up front. As I said, it's publishing agreement. And so we're going to look at the standard clauses that really are in any copyright agreement. First, we'll look at the license, the license grant. So what rights are you granting to, what rights is the licensor granting to the licensee? So if we pretend, I guess because licensor and licensee kind of confuse them sometimes. So if I am the licensor, I'm the publisher.
Licensor, you're the author.
Right, sorry, the author. Yeah. Licensor, the author. So let's pretend here I wrote the book that we're going to enter into a publishing agreement about. And Kim will act as the licensee. So she will be the publishing company. So what are we going to look at with a license grant? We're going to look at the who. We're going to look at the what, the where. Are we licensing it? What languages are we licensing it in? How long are we licensing it? And what are the fields of use that I am licensing my book to Kim? Do you want to take this part?
So for the who, one of the aspects are I'm granting you a license to do a certain thing. Do I want you, it's me now, but anyway, the publisher or whoever I'm giving the rights to, do I want them to be able to sublicense this? Or is this a real personal relationship? This is a trust thing. I have said, I want you to handle my work the way I intended. We've had this conversation. We're now putting it in writing. Or do you not care? Do you just want somebody who has a machine and a marketing department and a good printer to get this thing out there? And so that's kind of where the who comes in. Who are these rights given to in the first instance? Who's a named party? But then who do they have any freedom to assign this or sublicense it or whatever? The what? This makes it very easy if you have a copyright registration, because it's a lot easier to refer to a copyright registration number than to try and describe the work in sufficient detail to kind of do the metes and bounds of what it is you're giving away. I think if it's a manuscript, that's fairly straightforward. If it's a series of works, like your spring collection, what if one falls out? Do you have to list them all? What if you haven't titled them? It can obviously be a little difficult. So that makes it easier if you have the what defined by a copyright license, for example. And the where and the what languages, do you want to speak to that? Or?
Yeah.
Okay.
So, and I'll speak specifically to this license that you have in front of you. If you look on the first page, it says right there, granting of publishing rights. But then up here, we've broken down some specifics. So who is granting? It's the author's granting. Who is he? Who am I? Who is he granting it to? I'm granting it to the publisher. What am I granting? The work is their second arrow here. So the work is defined, I believe, earlier in the agreement, or there's where it's blank on that first page in the second paragraph. That's where you would include the work that you're. The what? What are you granting?
If it's really extensive, you'll put it on Appendix A, right?
Yeah.
It'll be like 4 pages of stuff. And you'll notice here they did do successors, representative, and assigned. So this is pretty broad. This is publisher and anybody the publisher wants to do business with. So that's kind of broad.
So this agreement, and I'm sure you agree, is very publisher, licensee.
It's positive in their favor, but it's not
Right.
as bad as I've seen.
Right,
I've seen
yes.
horrible ones. This one's pretty fair.
And so the where and the what. So that's where are we licensing these rights? Are we licensing them in the United States? In this license, yes, we're licensing them in the United States, but we're also licensing them in Canada. And I believe further on in the license, we give rights, yes, we give rights to the United Kingdoms as well. Mm-hmm. And in the different languages, or the different, I guess, dialects in the UK.
Right.
Is that?
Right. In our territories and dependencies and stuff like that. So.
And then how long? How long are we licensing the rights that I have to the publisher? How long is the author licensing those rights? In this case, it's the life of the copyright. So the full term is what we're granting here. So that's my life plus 70 years.
So that's a very, very generous grant. Yes.
So this is just an example, but if I was your customer and the author, would you recommend me to accept such a long term?
So what I usually recommend people, because there's a couple of things at play here. I am super excited a publisher's talking to me. I really want to get this work out there. That's totally legitimate. That we take that backdrop against what we've been approached with a particular publisher. And they're going to have standard documents that they're comfortable using. And they're going to be pretty pushy about what they're going to use. So what I will say is let's read it through and we'll have our hit list. We'll have our top 10 things that we cannot live with. And then we'll pick 5 and we'll go to the mat. And so you end up deciding what those are. In each case, some of them that I've seen, and I don't want to get too off into the weeds already, but term is certainly one of them. But I think if you've controlled how they can use it, in what ways, and in what manners, time may not be your problem. So you may be fine with the longevity of it if you've controlled how you get paid, what requirements they have to give you, because you're looking for something from them other than printing, because you can self-publish at this point. So you're looking for marketing, you're looking for other things. So to answer your question, it really depends, but I think term is not usually the worst case scenario. What you want to make sure of, though, is that anything that you don't grant them when you've done all the other limitations are yours, but you might as well come out and say it. Like, this has been retained by the author, so that there's no misconceptions about what you're retaining and what you're giving away.
I think it's also a balancing, like you said.
Yeah.
You come to the table with these top items that you want to fight, or not fight, but you want to negotiate.
Right.
And you really balance, is the term worth how much you're receiving as a monetary benefit?
Exposure.
How important is it to you that you work with this particular publisher or whoever the other party is?
Because the other aspect to term is termination, the ability to cut this thing short if something doesn't happen properly. So if you've got a good termination clause that favors you, that says, if I'm not happy with X, Y, or Z, I'm out of this thing, and so are you, then terms kind of like, as long as we're getting along, everything's great. What you just want to make sure of, though, is that you can get out, because sometimes they're written in such a way that the only person that can terminate it is the publisher, essentially. And so you've given everything away. You can't get out of it if they don't perform the way you expect them to. And then that's when term's huge, because you've given away way too much.
I believe this license, that's how the termination is set up.
Yeah.
So another key or standard clause is the representation and warranties. So these clauses highlight what you as an author are claiming or representing to the publisher or the licensee, and then what warranties are you giving to the work that you've created, and what warranties is the licensee offering.
Right. And so these will come down to things like that you have the authority to enter into this contract. For example, you don't have another exclusive contract with another publisher that already gave this away. Like, so some of these sound silly, but it's helpful in certain contexts to outline that somewhere. So you have the authority to do it, that it's an original work. You want to make sure, especially if you're on the receiving end of a work, you want to make sure, say, for example, you've commissioned somebody to do a logo or a front cover of something or whatever. You want to make sure they haven't lifted it from somewhere, because you don't want somebody to come back and sue you and say, oh, this is copyright infringement, and you're like, well, they said that this was their work. So you want it, that's called indemnification. So basically it says that not only am I going to represent to you that it's original, but I'm going to warrant to you that I will indemnify you, I'll protect you, I'll stand in your shoes if someone comes after you because of something I did wrong. So those are pretty common provisions.
Do you find that something that comes up a lot, that you have to negotiate either side when you're working with clients?
The publisher will not wiggle on that one. That's one of those ones where they're like, if you're wiggling about whether or not this is original and you're going to stand by your work, I think we're all set. That's one of those ones that's like flags go up. So you pretty much have to do that. I think you just want to tailor it into do claims have to be known? Do they have to be legitimate? Do you have to pursue them? Sometimes you can just settle, right? You don't want to have clauses in there that require you to go to court and fight this stuff. So the indemnification can look different, and that's where you can negotiate more. Not so much that you don't have to warrant that it's original work, but yeah. And then, like I said before, the no conflicting licenses can be pretty important.
So in the agreement we have here, if you look, I think it's page 2, where it says author's warranties and indemnity. That first arrow that I have up here highlights that original work. Oh, excuse me. No, that's that you have the right to enter into the agreement. That I, the author, have the right to enter into this agreement, and then that it's a work, an original work. And then, the indemnification section is this third arrow here, where I am indemnifying myself in case somebody decides to come at the publisher saying that they have some ownership rights in the work that I've granted the publisher rights to. And this section also talks about that there is no conflicting license already out there for the work that I'm licensing.
And then there's an interesting clause here, C, talks about if there's some agreement as to whether or not this is going to proceed to court if something happens, and then there's the ability to withhold that approval of going and asserting essentially their copyright. It's still your copyright because you've withheld something. And then they can say, that if they unreasonably withhold it, then they might be liable for the publisher's fees and stuff like that. So, like you said, it's pretty publisher heavy.
And I've just based on publishing agreements I've reviewed, I find that if you see in D, that this section, the agreement claims this section will survive any termination of the agreement. That is, I think, pretty common that you'll see that, because the publisher's not going to want to take the chance that down the road, maybe you've terminated the agreement, but even further down the road, Kate's going to come along and say that she had a part or she is the true owner of the work that I created. So that could exist for a very long time.
That's right.
Any questions on reps or warranties before I move past those?
Usually the publisher will be pretty light on their reps and warranties. What you'd like to see is that they represent that they have qualified staff capable of marketing, that they have a network of people, that their print house is always running. Like, you want to know that they're going to do what you think they're going to do, because this is the idea is that you're going to get it out there and they're going to do a really great job. So you're going to want to see, obviously, their authority to enter into the contract. I think if it's a corporation, it's pretty clear. I think when it's an individual, you like to see that laid out so that it's not the co-author problem or something. But yeah, go ahead.
So is that also going to be mentioned as a part of this agreement in sufficient detail?
Their
Or
reps?
Or is that going to be a separate document with the publisher?
No, it should all be in this. And oftentimes, we'll get to that at the end, there's a section called Other. And that would be like choice of law, what state do you have to sue in, that sort of thing. That is where it's going to say that this is the entire agreement. And any verbal conversations we might have had, any understandings we might have had, are either in this document in writing or they don't exist. And that's where that's going to come in. Every once in a while, you'll have a subordinate document that'll come in, but not usually in a publishing contract. That would be more of like in a business context, where you're going to be licensing the sale of goods and a trademark license, and you want them to kind of stand separately. Like, one might have purchase order requirements, and one might have quality control measures, and you don't really want to mix it too much, because frankly, it's a lot to digest. But in a publishing contract, it's just the one relationship. I'm giving you the copyright. You're going to give me marketing and distribution. And so you tend to keep it all in one spot.
Because it seems like it's heavily loaded in favor of the publisher. The language
Yeah.
and everything.
I've seen some really
And I'm
horrific
wondering,
ones. Yeah.
Would you be able to provide another specimen copy of a document which kind of protects the author's rights and lists those in sufficient?
Well, I think the important thing, and I think I say it later, so I might as well say it now, the idea of this is just one snapshot, and this is an agreement between two parties. I would highly dissuade anybody from using, certainly the document, but even a clause, because every clause has been overly negotiated by people like me, where every word counts and it matters for the parties. And so you can certainly look online and peek around and see pro-licensor clauses for particular things. But I think the simpler you can make it, the better too. Like in a publishing context, though, they're going to be supplying them. They're the machine that you're going to. If it's a commissioned work and you're trying to commission an artist, or you're an artist that's going to do a commissioned work, you can really spell out exactly what the clauses say. And like the example that you showed me, they can be incredibly straightforward and simple, and they should be really, because
That's
it should be in English. You know, but when the publishing contracts, they tend to be written by a team of lawyers over time.
Mm-hmm.
Yeah, go ahead.
Yeah, I'm a licensing agent, and what I say is, because I get these agreements and they're completely one-sided, that the rule of my agency is that they use the agreement that I have with my clients. And that's, I would say, 95% of the case, that's what we do. And the one that I have is really balanced, and it's not so bent to the other side. And sometimes they'll do it, and sometimes they won't, and then you have to decide.
So if I understand you correctly, what you're saying is for the person who's the intellectual, the property IP owner, it would make sense for them to go with the licensing agent and have something worked out.
Or go to a lawyer and work with a lawyer to develop the document for you that you want to use.
You want.
Yeah.
That's what I've done for my clients, and that's the document we use. Now, like, that's my rule of thumb, because I get these documents that are outrageous.
Yeah.
Outrageous, and they think, particularly with artists, that they can get away with a lot, and they could.
And they do.
They do.
Yeah.
And there's a lot of horror stories about it. So that's a really important part, is have a lawyer or an agent who's going to look after your interests.
And I think if cost is an issue, sometimes the best way, like if you can have somebody draft you a document and send it across their desk, sometimes they'll take it. But the other way, too, is just to pick, like I said, pick a couple clauses that are absolutely horrible and fight those and say, can you change these 7 words? Because first of all, it'll take us less time to manipulate language that's already there. But also, it's a little easier for them to digest sometimes. If it's essentially their document and you just want a few tweaks, they'll know that they won on a lot of other points, and so they might be more inclined to take it.
But as you said, and I've had this experience, that it's really, their documents are really crafted
Oh, yeah.
carefully. And as a layperson, I mean, I'm good enough to be, I'm dangerous. I know
Right,
enough
right.
to be dangerous. But sometimes you read it and it sounds fine, but it really isn't
No,
fine.
that's right, right.
So, that's why I think having a lawyer that's drafted a document, or at least looked at the publishing contract that you got from.
Yeah, and I think it's like, to your point, you're going to be pro-licensor, and so yours will translate to other medium.
Right.
You may need to tweak it a little bit from artist to artist, but there is such a document that could be easily manipulated, just like theirs, yeah.
Yeah, 95% of the time, even with publishing contracts, I insist that they use ours, because we are the licensor, we are the owner, so we're calling these shots.
Well, and I think that helps, too, to go into that position. I think, that, like I was saying before, it's balanced against this, yay, they're talking to me phenomenon, and it is good, but a lot can get lost if you're too excited,
Yeah,
because they can see that.
Sally feels they love me, they love me.
That's right, exactly.
I mean, that happens a lot here at UNH. I mean, our office reviews publishing agreements for faculty. So if you're faculty and you have a publishing agreement that comes across your desk, usually either Maria or I get a call that's, yay, somebody wants to publish me, and then I say congratulations, but do you want to send that agreement over just so that we can take a peek? We're not going to negotiate it for you because, as Maria is talking about right now, publications, the type of publication you would enter this type of agreement for is considered an exempted scholarly work, so UNH takes no ownership rights in that work, but we're happy to look through the agreement and point out things you should consider, or if it's extremely one-sided for the licensee, the publisher, I'm very happy to point that out to people and recommend that you go talk to somebody outside, legal counsel outside, to help you negotiate those type of agreements. Actually, I have one sitting on my desk right now that I'm meeting about tomorrow that is very licensee. It benefits them a lot.
So delivery. So this is again, we're using a publishing contract. This could be any number of creative works, but we're using publishing. So this is like, what does the manuscript need to look like, and when do you need to get it to them? And then you're going to look for provisions that say, what if it's not in the proper form, which has been defined within, right, by a certain time? And who can make those changes? A lot of the pro-licensee ones will say, the publisher's more than happy to make the final edits. We're going to have our artistic discretion. We're going to make whatever edits we want, and we're going to charge you for them because our people are expensive and it's time. And you're like, well, wait a minute. First of all, it's my work. I'd really rather make the edits myself. And second of all, how am I getting charged? Yeah, so those are big ones that hide. So who bears the cost? The clearance of copyright within a work. This is, I didn't sit in on the fair use one, but I've lived in that world a little bit. And there's certainly things that fall into fair use, and you should have a good understanding of when something might, and then seek counsel. Because there's a lot of times that you can spend a lot of money trying to clear works that don't need clearance. They're actually, what you're trying to do is fair. Particularly in the scholarly setting. You might be producing something with about art history, and you're showing the differences between types of work or something like that. So you want to make sure the clearance of copyright is clear. They will charge you an arm and a leg because it'll take a lot of time, as we talked about before with orphaned works. Any number of problems with trying to get clearance, and even just negotiating that clearance with someone could be costly. So. A lot of times I've seen them written where your full manuscript is considered submitted and done when all clearance has been done, but it's also been fully documented. Like you've written out who you called, what they said. Like it can be very extensive work, but you want to be careful if they're going to charge you for the clearance and what that looks like, because if it says clearance of all necessary and then you've indemnified them against any that should have been clear but weren't, then they shouldn't be charging you to go clear the ones that don't need clearing, for example. And then, again, the editor's revisions. You want to make sure that you have at least some feedback, because you could end up with like a sequel almost. Like they can just really go off somewhere. They could change the ending. They could change a character. You want to make sure that if they are revising it, they're revising grammatical errors or something like that. You don't want them in there rewriting anything.
Do you ever see where the licensor can bring with him or her the clearance? Has that ever happened?
Yes, it's usually required that the artists clear everything.
Oh, the artist. Oh.
But how they write it is, if you haven't done it, we'll do it, but we'll charge you. And then that's where it gets crazy, is because they're going to, again, their time, time is money, and if you're going to pay them, they'll certainly spend a couple of days clearing stuff for you at their billing rate in New York or wherever they are. So yeah, usually it does say that you're supposed to clear it because you're the author. The thought process, I think, is that you're closer to the work. You know where you found it. At least your boots on the ground. You can find stuff easier, cheaper.
So what do you recommend that the author has in those type of situations? Just waivers, or like what would you recommend for a client to bring?
I think just to if it's clear that you need clearance, then you want to if you can get it in writing, obviously that's great. You want to have some kind of feedback from the licensor that you have permission to use it in your limited context. One of the things I would say is, if you're seeking permission, know what you need. And be, and not ask for the world. Like, can I use your stuff any way I want to? No, I need it for this one publication, for this limited run, in the United States only, in English, And then if you're approaching them with something pretty narrow, the chances of someone approving it is good. But I do think it's worth approaching someone who has some experience in fair use and discussing whether or not you even need it. Because I think there have been cases, certainly, where you've approached someone for permission that you didn't need in the first place, and all of a sudden they see money. And it becomes an embroiled mess where you really didn't need the permission, but now you've asked. Now they know about you. And not to say that it's better to ask, for forgiveness than permission, but it does get into a weird situation where if you legitimately didn't need it at all because it's scholarly work or something, then you might have created a problem for you. Another aspect, though, too, is if you're going to have the publisher do the clearance, then I would rework the indemnification provision and say, I don't know, you're the one that seeked all the permissions, so why don't you carry the weight of defending me if you're wrong? So I would play those against each other, and maybe even just say, okay, you can clear it, but I'll pay up to this amount or something. You just use it as a negotiation tactic. If they're going to insist on doing all the clearance at their cost, then they should carry some of that risk.
It's a great example that I have of the clearance pieces. UNH owns a number of close to 50,000 images done by Lotte Jacobi, which she's, if you don't know who she is or was, she's basically the Annie Leibovitz of her time. And UNH owns the copyrights in close to 50,000 of her images. So I get approached on a weekly basis, typically by authors looking to clear use of an image. Only on rare occasion has it been a publisher.
Right.
So in the license in front of you, example of what quality and timing looks like is on page 4, section 4, which outlines delivery of the manuscript. And this is a great example of pretty detailed, and what you as an author, I think, would want of how the manuscript that you're developing has to be delivered.
I think the hard part is, we could spend all day nitpicking words, but, in a content-informed satisfactory to the publisher, spell it out. What are you looking for? And they do, thankfully. They say, I want it in floppy disks, I want it to be formatted so it's compatible with Word. Okay, fine, I can do that. But you don't want something so open-ended as, that it meets my approval. And you're like, well, what's that mean?
What's your approval
Especially
mean?
if things start to happen to you after a certain date. Because usually they'll have the initial delivery date, then they'll have the editing process, and then they'll have, when it's supposed to hit the next phase. And we'll talk about that in a minute, too, about like what are they supposed to do and by when. Because oftentimes they're silent
Yes.
about anything that they have to do. But you just want to make sure you understand that. Pick your battles, but.
So in that same section, sections 4A and C outline provisions if they're not in, if part of the manuscript's not in the proper form, or at least not in the proper form according to how the publisher's defined, or how you've negotiated it.
It's typical to have this cure aspect in C. It says an author shall cure any defects. That's typical. If you're delivering a good to somebody and they have the ability to reject it, you have the ability to fix it. So that's pretty standard. But you might want to, depending on the contract, you might want to spell what that looks like. Like, how quickly do you have to turn it around? If you only have 5 days to fix all the problems, that's not really sufficient. 30 might be too long. I don't know, but that's where you might be able to get a little wiggle room.
Would you negotiate when something's vague or at least not specific on the number of days? Like, so this agreement says promptly, materials promptly returned after receipt.
Yeah. I would say within 5 business days or whatever. I would want that spelled out. Again, you do have to somewhat pick your battles. If you're going to go to the mat on things and there's some things that are super critical, promptly might not kill you, but in a perfect world. Like if I was writing my own, then I would define it. But if I was going to bat for a client, I might say, okay, we're going to have to let a couple of these slide. Which one's least hurtful and upsetting to you? So.
The clearance of copyright within a work, that's in section 4B1. Yep. And then the editor's revision. I'm not sure why I highlighted this in red, but
yeah, that's right.
That's in section 6 of this agreement.
Yeah, I think there's a lot going on here, but certainly, they consult with the author, but the publisher has the right but not the obligation to publish and republish the work at its own expense. I mean, that's nice for them to say, but they're going to get a lot out of this. But then they say, as it deems suitable, except in the initial publication that's agreed on in the price. So this starts to tease out some of the things we'll talk about later, which is sometimes they'll exempt out certain copies, like certain copies won't count towards your royalties and stuff like that. We'll talk about that in a minute. But I worry when I start seeing things like they'll publish them whenever they want and in whatever form later. But today, we'll agree on the first run, but the second, third, fourth runs are all up to us. And it's just, you want to understand what that means to you. Again, if you get great market exposure and you're getting a decent royalty rate, go for it. I mean, but you just want to make sure you understand that the first run doesn't end up getting comped, and then the second run's the moneymaker, and you're cut out of it somehow. So.
Next standard clause is the royalties and payments, the money, right. The good stuff. So all agreements really, in this agreement, should outline royalties, like how much you're going to make off a certain number of sales, when do they start, how long do the payments last, when you're going to be paid. For publishing agreements, you see many times advances to help you through that process of actually creating the manuscript. Right. How are the royalties calculated, and then how you have access to the records. You being the author have access to the records where you get a chance to actually look to see what sales look like.
Yeah. And I think one of these pieces here that are the costs deducted. So you might get an advance of $5,000 and you're like, yes, I'm taking the family to Disneyland. But then you realize that all of the things that the publisher is going to do for you, they're going to deduct as costs. And so all of a sudden, your check is really tiny. So just make sure you understand how the money flows back and forth. And in some cases, it's worth just getting out there, and other times it's really worth sticking to your guns in the beginning.
So this license, when do they start, and is there an advance? If we look on under Section 13, royalties, right in that first paragraph, it outlines whether or not there's an advance. I mean, there's a blank spot for what that advance could look like, and then when that happens, when that occurs. So what if the publisher never publishes, and how that relates to your royalties and your payments? That's it's in the agreement a bit earlier under, I think it's section 4C. No, sorry, 6C.
I think the key here is 18 months doesn't sound terrible if they have a lot of revising to do. And maybe they have cover art they need to work on. Maybe there's a lot of formatting. I don't know, but that could be an awfully long time to find out that this is a bust. Depending on what you're publishing on, sometimes being first is as important as being the best. And so I think sometimes you might want to look at that. 10 days to turn around a proof. Again, if this is a 400-page manuscript, that's not a lot of time. So they're all of a sudden they're exempted out. They can consider it a cause beyond their control if they didn't get their proofs back in 10 days. Well, again, that's the kind of stuff you want to be careful about. And then, again, that gives you the ability, but it's not an automatic termination. It's just then there's probably termination provisions, like you have to write to them. They have the ability to cure it. 18 months might be 24 months by the time you've actually officially terminated this thing. Again, just it's not a horrible number. I've seen plenty of contracts where there is literally no obligation of the publisher to publish it ever that I could see in the document. So 18 months is something. At least they're saying that they promised to do something by 18 months. So that's good. Calculations.
Do you want to hand? I have a question for you.
Oh, sure.
So if you want to.
So the calculation of royalties can vary. Usually it's going to be after they have deducted all of their costs. So the net proceeds are then going to be distributed at a certain percentage to you. So again, in that calculation, you want to understand what are they deducting. Is it part of the quid pro quo? Are you expecting them to do some things that aren't going to cost, that you shouldn't also be charged for? Because essentially that's what's happening. It's never going to be gross, but it should be, the net can still be calculated in different ways. Certain percents, this is fairly typical where, say, for example, the first 10,000 copies are going to be at a certain percent, the next 15,000 will be a different percent, and so on and so forth. What is almost as important as the percent that you're getting for these particular runs is what's counted in a run. I had a client who came to me after she already entered in the first publishing contract, but before the second. The first one was horrific, and they literally did not count ebooks, and they completely plugged it that way. They used hers as a way of comping to get stores to buy other books. So hers were always given away free. So there were thousands and thousands of her books that made it out there, so she was thrilled that her book was read. So it made way for her second book, which she did make money on, because she had already built up a fan base. But it was it was a sad story that basically all of the stuff that they had done somehow fell into a category of not counting towards a royalty. So, and she had gotten a $4,000 advance, so that was essentially all she got.
Can we go back to the previous slide?
Oh, yes.
I wanted to ask, what is more common in that first paragraph? Because the percentage changes for the amount of book.
Yes.
One is that the percentage for the author goes up because he's a good seller, or goes down because he's already getting too much money.
That can vary. I think I do think that they tend to it goes up a little bit if it's selling really great, because they're happy to share at that point, because their work is kind of done too. The marketing arm has already happened, the formatting's happened, the print's already set up. So running another 15,000 books is pretty light work on the publishing end. So they'll give you a little bit more.
And a second question, and it probably is the hardest one. I'm John Doe. Nobody knows me. What should I expect to be a decent percentage of royalties?
Oh, you'd know better than I do what the market bears is the answer always.
I'm going to talk about that in the next section, but it depends. It depends what markets it's in. If you're talking about books, is it in Walmart, which has huge distribution, so the royalty rate would be lower because they're giving you huge. Is it in a gift store or something that has smaller amount of volume? Royalty rate would be higher. So by industry, there are standards, and by product. But typically in the mass market, the royalty rate is going to be on the low end since the volume is big. And if you're selling to Walmart, it's one thing. If you're selling to Tiffany's, it's another.
I'd say another example of a royalty structure similar to this is a trademark license that we have with a company, where we break it down similarly, but we break it down on quarterly sales. Mm-hmm. So if the company only sells $250,000 worth of merchandise, our rate is lower than it is if they sell $500,000 worth, or our percentage is lower. It's higher if they sell $500,000 worth of merchandise in a quarter. This just continues to talk about how the royalty rates and payments the royalty rates are calculated, which continues in that 13 royalty section. Do you find in most agreements that the royalty section and payment section is the longest?
Yeah, I think it is, and I think that's because, but I think it's because they put in a lot of verbiage where they can get out. I think that's where the things hide about the promotional, because they say promotional, yeah, promote me. That's what I'm hiring you to do. But promotional can mean they give your stuff away for free. So that's the scary zone, I think.
One of the other things that to be really careful is I've had people deal with publishers and they get an advance and they're really excited, but the advance says refundable. So if they don't make the royalty that equals that amount, you have to pay them back.
Right.
So
Right.
always make sure that your advance is non-refundable.
That's a good
Your
point.
money.
Yeah, that's right. That's right. The access to records, I mean, I think, this is one of those things you say, yeah, sure. But in this case with this first, the author I was speaking of before, I think it's really important. You need to be able to look under the hood and find out, did this legitimately not sell? Did they really comp them all? You start to wonder when it's such a one-sided agreement and it did have a lot of sales, and yet the author's not making any money. You want to at least be able to review the records and find out if anything fishy happened there. There's usually some standard stuff here. It can be as infrequent as yearly, which you don't want. Quarterly, I think is fair. I think anything more than that is unrealistic because you don't really know what you're looking at. You're going to have to get somebody to help you look at their records. But I think quarterly at least says to them that you're sophisticated enough to have some expectations. And like, for example, with the 18 months, if you've looked at it 3 times or more in 18 months, then at the time 18 months rolls around, it's pretty clear nothing's happening. But if you can see that the wheels are turning and that they are expending money and that things are happening on in the document, then maybe you don't want to flick the termination switch. Maybe it's fine. That's just my 2 cents.
Great.
What is your thinking about the term best efforts?
Oh,
That's
yeah.
a term that it just drives me wild. And again, how much can you press these people? Because as you were saying, this is so true in not only the book publishing, but in music publishing.
Oh, I bet. Yeah.
People are so desperate to get those CDs and to get them out on the market. If
Right.
that's the way, I'm not even sure it's going to be a business plan.
No, I
I'm not
agree.
sure anyway.
Right.
But as of today.
That's right.
I don't-
I didn't check the newspaper this morning.
Right.
But,
I don't think it's one of those things that hurts to ask for some clarification on it.
Right, exactly.
That's what
Yeah.
I always say, get them to the best efforts. It worked for, what was it, Lady Duff Gordon. I really want them to say something
Right.
within 90 days.
Yep, and like for the author, if I have to give you a manuscript that's formatted in Word and is ready for press, then I should be able to say to you at 6 months that you should have a marketing plan designed and implemented. You should have whatever. Like there should be something concrete that I could look to that's not just your best efforts, whatever those might be. Yeah. Yeah.
One of the things that I do is I put in a marketing date in a contract.
Great.
And if they do not meet that marketing date, and I negotiate that with them, then the licensor has the right to terminate.
Yeah, absolutely.
the contract.
Absolutely.
Yeah.
And then all the rights revert back.
Absolutely.
So we're really flexible, and I usually ask them, when do you expect to be in the market? And I'll put it,
Right, and put
out
2
there.
weeks out or whatever, yeah,
It's
wiggle,
months
yeah,
and,
right.
maybe up to a year or something.
Right.
But, if they don't meet that target date, you call them up and say, what's going on? Oh, yeah, well, we're not doing it or whatever, then you can terminate.
Exactly. No, I think that's a great idea.
What about things like translations and ebooks and audiobooks? I try to keep those out of this initially, and again,
I do too.
but you don't have much luck, do you?
It really depends. Yeah, I mean, I think it depends. Not to be weird, but I think it depends on how much they want the book,
Yeah.
how much what kind of interest there is on the other side, and the sophistication of the parties. Not to be weird, but some of these publishing houses really have no business doing that. And then there's other ones that are well known for being fantastic publishers, and they may have a very strong contract, but they're reasonable people.
Yeah.
And so I think in that case you could negotiate that, or maybe just negotiate a different royalty or a different treatment, different marketing dates or what have you, if you wanted to. But yeah, I do recommend either carving them out or at least treating them differently. And the same with derivative works. I'm not sure where we'll talk about that. Maybe later. Yeah.
I think, yeah.
But yeah, okay. So for expiration and termination, you want to have a couple of different things here. particularly when we were saying before about how long is the grant. If the grant's forever, then obviously you don't need to worry too much about renewals. But if it's not forever, you want to make sure you haven't got a perpetual license or a perpetual license that's written in such a way that you have to do some really weird things at weird times that you may miss. Like you have to give notice 6 months prior to the natural termination of this agreement is written, and that day goes by, and then you're like, now how do I terminate? Am I stuck in the loop? Have I auto-renewed for another 3 years? Like, so you want to just make sure you understand how it ends, and calendar it maybe if you're worried about it. But just have an understanding if it is a perpetual license, if it isn't from the grant being forever, but it's the nature of how you can terminate. I think with notice by either party is pretty generous. I don't know that I've seen a lot of it. Because I think what's happening there is people are taking a risk. They're taking a risk on you. They're going to scale up. They're going to market you. They're going to promote you. They're going to print it. They're going to do all this stuff. They don't want you to be able to turn around on a Tuesday and just give them 30 days notice and say you want out. So that's not likely to be there. But for breach, it should be there, and that was what Linda was saying. Both sides should have that. If you haven't given them the manuscript in the way that they want to see it, or you haven't cleared the copyright adequately, or something else weird is happening, and they want to terminate, you should have the same thing. If they're not meeting their marketing benchmarks, they haven't sold any copies in a certain amount of time, and that sort of thing. In the marketing aspect, there'll usually be a requirement that you cooperate with their marketing. You sometimes want to spell that out depending on your artist. Someone may not have any interest or desire or willingness to go on the bookstore circuit, for example. And if it's written in there that it's required, that could be a breach. So you want to make sure that while you want to promote your work, if you're hiring them to be the vehicle to promote you, and you say, go ahead and use my likeness all you want, take a picture and say whatever you want about me, it's fine, but don't require me to be there all the time. So some of that stuff needs to be spelled out. Again, it's pretty case specific, I think, on that kind of marketing stuff.
I think in light of timing,
oh, sure.
I think key for this section, and you'll get these slides too, so you can look through where each section that we're talking about in the expiration and the termination. The key, though, I think, is that with these type of agreements, there are termination clauses throughout the entire document, or reasons that will cause for breach that you just want to make sure you are aware of.
Right.
Like if you see these three slides here are three very different areas of where there are some termination language.
So we can go very quickly through the general provisions. So this is going to be things like, we said before, if I need to send notice to somebody, who do I send it to? That's notice. Choice of law, am I going to sue in a New Hampshire court, or am I going to end up in the Southern District of California because that's where the publisher is? That can be good and bad. You should at least know what you're getting into. Integration and severability, that comes down to, there's something called the blue pencil rule. If somebody it goes to court and the judge is reading it, this is a ridiculous statement, you can't say this isn't legal. You want to make sure that they can excise the offending portion, but the rest of the document survives. That's a standard clause. Modification, that's the same idea where we were saying before, this is the complete agreement. And you want to say in there that if this is going to be modified, it needs to be in writing and signed and all that sort of thing. So we can kind of just go right through that, I think.
Yeah. Again, this is not necessarily boilerplate, but I mean, you'll see this in every type of agreement, these general provisions.
There's no mediation arbitration.
There is
That's
not.
right.
Yeah.
Did you see?
No, I know. Yeah. Yeah.
I actually have a lot of people push back on that when you include language like that. If you include, this is what will happen, if you include arbitration and mediation clauses.
The publisher pushes that.
Not necessarily, well, just other agreements, because an agreement that I shared with Kim when we were trying to decide which agreement to look at here, the one that I drafted is very simple. It's, what was it, a page and a half?
Yeah.
Front and back, because we use that license on a regular basis, at least maybe five times a week. And so I don't want to have to negotiate with 5 different people every week for the same thing. So it's a very straightforward license. And I did have some dispute resolution, which is, if you don't know what that is, that's a clause where if there's a disagreement between us, this is what we're going to do first. We're going to try to go to arbitration, or we're going to try to mediate a settlement or some sort of agreement rather than suing each other.
Right.
But yeah, I was finding that I was getting a lot of pushback on that particular clause. I don't know if you have that.
I put it in all my clauses, and this is exactly what's going to happen and where it's going to happen, and I deal with all kinds of industries, and I basically sign it.
Oh, I deal with a lot of schools, so that might be why.
So from the pro licensor side, these are the types of things that if I was going to say pick your battles, these are the types of things I'd say look for first. Recording your own copyright, they sound so generous. We'd be happy to record the copyright in your behalf, and then you can license it to us for eternity, for nothing. No, but so record the copyright. It takes you maybe an hour to fill out the form. If you're needing to read the instructions, it's $35-ish. Definitely do it. I mean, to some degree, it shows a level of sophistication, but it also shows that, do you want to negotiate with me or not? I actually have this thing. I understand enough about it that I've registered it. Now I would be happy to talk about how you can use it with my permission for a certain fee. Like, it sets the tone, I think. You're going to want to retain the right to create derivative works. In some instances, it may be a bit of a throwaway. Is there going to be a screenplay about your owner's manual? Probably not, right? But there might be, in certain instances, where the derivative works are where it's at. Once you've built the foundation for this thing, somebody can come up with some follow-on stuff and really be making a lot of money. So you want to make sure you at least retain them and carve them out and understand some of the things that other of the bad publishing contracts that I've seen are, we get the first refusal for your next book. That's sort of generous because at least you can refuse. Others say, you just give us your next book. We'll just take it. Whatever it is, it's ours, and we'll publish it under these terms. So you want to be careful of that one. Set time for performance, we've already talked about. Include the ebooks, only because now it's so easy for them to churn out a gazillion ebooks. And if your copy count doesn't count those, I know I don't read anything in hardcover anymore. It's not that I don't love it. It's just when I'm traveling, I don't want to carry an 800-page book with me. And just who gets to direct the enforcement efforts? If somebody is found to infringe, you probably want the strength of the publisher to come down on them, but you don't want the cost to be on your doorstep. So that's copyright infringement enforcement. Limit the giveaways, only because I've seen it go horribly badly. And just shorten the term of the contract based on benchmarks, like you said before. If they haven't met something, it terminates. Yeah. Yeah, I already said those. Cool. Pro licensee, do you want?
Yeah, I'll start with this.
Cool.
So these are kind of the opposite of what you were just saying on pro licensor. So the licensee is going to want to be able to create derivative works. So that's something that you would likely see that will benefit them. No set dates for performance. That way they can pretty much use their own timetable to get things done. Unlimited giveaways for the opposite reason that Kim said. They're going to want to be able to give stuff away to be able to market it or potentially market somebody else's book.
Right.
Carve out for ebooks because those are so popular. They're going to want to be able to do that. It's cost effective for the licensee to have ebooks. There's no real cost to that other than I'm sure the fees that the Google and the other
and that'd be a
stores
carve out on the
charging.
royalty side, not on the permission side. Like they'll be free to make them, they just won't pay you for those.
Right.
That's
Approval of changes at licensor's expense. I mean, that's kind of a given that the licensee is going to want that, so they don't have to bear that cost.
Right.
No liquidated damages. Do you want to talk to this?
Yeah, so basically this would be one of those things where sometimes they'll write in your sole remedy is to terminate the contract or your sole remedy is whatever, and they'll just limit the remedies that you have available to you. And so basically this will be one of those cases where if they wander outside the lines of what they're allowed to do, what can you get? If you have to go and prove damages, that's really expensive. First of all, you need experts, and you're in a full-blown trial. You've had witnesses and depositions, and you've had discovery, and you're in it for years to get to that point. So you want to make sure that there's some kind of penalties written in there that say, they're not going to want them, but that's the kind of thing to look for. Is what's the remedies section say? You may not, as the licensor, be able to get a lot of things added in, but you want to make sure that they haven't been able to carve out a lot too. So, and so the liquidated damages would just be over and above of damages. If you didn't have to prove like actually lost sales, for example, that you'd have to get a marketing person in there and say what you could have sold had they not screwed up or whatever, and that's expensive. So, excellent.
Questions? I think as a takeaway, and feel free to add to this, I think what's key with licenses, if you're talking to an attorney, that's great, but if you don't have the resources to do that right away, really read the document that's in front of you. It takes some time if you're not familiar with them, but it's so important. Just read, because a lot of people will just be like, "Oh, yay! I'm so excited! I'm just going to sign away
And don't
all my rights."
assume it's you that doesn't understand it. Like, they're not clear. So I wouldn't feel like, "Oh my gosh, I should get this. This should be clearer to me," because they're kind of sometimes written purposefully, very, very to obfuscate what's going on. So yeah, seek help, either your office or mine or wherever. Awesome.
Great. Thank you.
you.